Your Honor, I feel like I'm in a unique situation. Over my years of being an attorney, I've never been in this particular situation where I am right now. And I've gotten to know Mr. O'Connor over the last few years fairly well. I feel like we have a good, healthy relationship. To be quite honest, I feel conflicted. I feel like the community deserves Mr. O'Connor to be committed for 10 years.
Good afternoon. The court would like to provide a friendly reminder that today's hearing is currently being live streamed for public viewing. This means for the entirety of the hearing, courtroom communication can be heard by those over Zoom and live stream. Please be mindful of your professional decorum through these hearings, both on and off the record, as it may be heard by all viewing.
1:28, we still have 50 more minutes.
What do we do if he's late? Wait for him, I guess.
Wait, I texted him. So
Text back.
not yet. Which means he's probably driving.
There he is.
It shouldn't be texting. There we go.
He's early.
You're early. You're a minute early. No apologies necessary.
Good, okay.
You need time to talk to your client at all, Mr. Davies?
Probably, if you don't mind. I apologize.
Probably use the jury room.
Thank you, Judge.
Everybody ready yet?
Yes, Your Honor.
Okay, let's go on the record. This is case number 19-10DC-1583, State of Nevada plaintiff versus John Kelly O'Connor. Can the parties identify themselves and who they represent?
Wade Mills on behalf of the state of Nevada, along with Chelsea Sanford.
Good afternoon, Your Honor. Richard Davies on behalf of Mr. John O'Connor, as president of court and in custody.
Okay, this is the time and place set for a risk assessment hearing. Have the parties, is there anything the parties want to? I guess I should ask, has everybody received the August 19th, 2021 comprehensive risk assessment by Lips Crossing Center?
Yes, Your Honor.
Defense has received that, Your Honor.
How are we going to proceed then?
Well, Your Honor, we did file the motion. We've received it. The recommendations are for that a secured facility, Your Honor. So we would just, first we'd ask this court to take judicial notice of all the previous proceedings in this case, along with the preliminary hearing transcript, which the court, I'm sure, has reviewed. And if you'd like just to hear argument, is that what your court is looking for at this moment?
Are you going to present evidence today or are we just?
No, Your Honor, I don't believe that there's been any opposition filed to our motion. And
My time.
yeah,
Your Honor, I feel like I'm in a unique situation. Over my years of being an attorney, I've never been in this particular situation where I am right now.
Neither have I. So.
Okay, good. And I've gotten to know Mr. O'Connor over the last few years fairly well. I feel like we have a good, healthy relationship. To be quite honest, I feel conflicted. I feel like the community deserves Mr. O'Connor to be committed for 10 years. That's my feelings.
Well, it's more than 10 years.
Yeah, I think this is the baseline. Okay. I know Mr. O'Connor may want me to put a spirited defense against that and want me to try to, object to that, find him, not a high risk, not a risk to the community through clear and convincing evidence. So if Mr. O'Connor wants an attorney who's going to stand up and say he deserves to not be found civilly committed, I'm not sure if I'm the right guy for that, based upon I've known this case for a long time. I don't live here, but I do have, I do come out here often enough where I feel like I'm responsible for my actions to this community, and I feel like I'm beholden to my own conscience. So I'm still kind of trying to walk a line here between representing Mr. O'Connor zealously, at the same time walk beholden to my own conscience. When I have to wake up and look at myself in the morning when I get up. So I did not file an opposition to this. I don't feel there should be an opposition to this. I feel like the state has the evidence to support the civil commitment. If this is essentially a perfunctory hearing, then I feel comfortable walking through it. But if Mr. O'Connor wants an attorney who's going to vigorously try to oppose a civil commitment, I don't think I'm the right guy. I'm looking for you for guidance, basically.
Well, how do I mean, if he's
Yeah,
not.
he can't
I've
canvass
already
him.
found that he isn't competent.
You can't, so it's hard to canvass him because he's
Yeah,
not
hard to
competent.
canvass him, yeah.
So that's I guess that's where the line I'm walking here too, because he's not competent enough to tell me whether or not he wants to be. I'm sure he doesn't want to be committed. Who does, right? At the same time, so that's where I am as an officer of the court, as the attorney for Mr. O'Connor. I've known you for a long time. I'm just kind of laying my cards on the table, letting you know where I'm at.
Well, you got the report. Do you have any objection on behalf of Mr. O'Connor for me considering that as evidence in this
I have
proceeding?
no foundation to try and traverse the reports.
Is there any, do you have any witnesses that you can call to?
I don't. No. I don't think I have any basis to try to traverse these findings.
Okay,
So I leave it at that.
so, Mr. Davies, I don't know what else you could do for Mr. O'Connor.
I appreciate you saying that.
Looking at the reports, he seems to understand these proceedings. It's just he's got this delusion, I guess, that causes him not to think that they can bring him to competence. That also causes him to think that he should be committed to Lakes Crossing. So I don't know what else I can say. Mr. O'Connor, did you have anything you want to say? You understand you understand the proceedings. I know from reading your responses to the medical professionals that you talked with. I'd certainly be willing to listen to anything you have to say. Anything? You let the record reflect you didn't say anything. Mr. Lane, do you want to make some comments?
Just briefly, Your Honor, as is noted in this risk assessment, Mr. O'Connor's insight into his illness is poor. And I'm quoting here from, this is page, at least on the fax copy that we have, is 17 of 18. The defendant's history demonstrates these symptoms would also significantly increase his risk for violence, including lethal violence towards others. Mr. O'Connor presents with numerous historical risk factors associated with an increased risk of future violence. Those factors are 1, an act of significant violence, 2, a history of relationship problems, 3, major mental disorder, 4, attitudes condoning violence, and 5, a history of poor compliance with recommended treatment. They go on to find therefore, it's in the writer's opinion, that's Dr. Patterson, that with a reasonable degree of psychological certainty, Mr. O'Connor requires the level of supervision provided by our forensic facility. As the court is aware, we wrote a lengthy motion on this, reflecting all the particular facts in this case. This was a very dangerous case with potential to harm many people. Killed Mr. Miller in front of his family. Wounded his brother. There's so many people who could have been, from a ricochet, injured. This is true dangerousness, Your Honor. And so, unfortunately, the victim's family didn't get to see a trial in this matter and have closure for this. Maybe someday they will, maybe not. But the law is such that we ask this court to commit this defendant to a secure psychiatric facility pursuant to subsection 4, 178, 461, for as long as possible.
Mr. Davies, did you have any response you want to make to that?
I don't, Your Honor. I think you made myself pretty clear.
Well, I've reviewed the report dated August 19th, 2021. I feel compelled to make some comments, and that is in our law, and this is long-standing, we're talking about much of the law that we have oftentimes, even though the legislature, every time they meet, feels compelled to change it, but we've had the common law that's been developed since about 1200, I think, starting with the Magna Carta. That's the year, probably within a century or two of that. And then we've developed a body of law that underlies all the statutes that we have these days. And there's a couple of instances in which we have come to believe that we shouldn't proceed like we would against other people. One is a situation like this where the defendant is found to have been incompetent or is incompetent. Another instance would be there's a presumption in the law that a child under 7 years of age doesn't have the requisite mentality to form the intents necessary to commit crimes like murder and other crimes. There's also a rebuttable presumption that children under 14 don't have that requisite ability to form an intent to commit a crime. Almost every crime in the law requires both a specific intent and the act itself. In this case, it would be an intent to kill and then the actual act of killing. In this case, because Mr. O'Connor is not competent, he doesn't have the requisite specific intent to commit the crime that he's charged with. And because of that, we have a bunch of statutes which, if the legislature were going to change, they could try to make more clear, but I have to make a finding by clear and convincing evidence. And as a matter of fact, I could make it beyond a reasonable doubt, which is even a higher standard, that Mr. O'Connor is incompetent with no substantial probability of attaining competency in the foreseeable future. And so I find that he has a mental disorder as provided for by NRS 178.3985. I further find beyond a reasonable doubt, clearly by clear and convincing evidence, that he remains a danger to himself and others. And finally, I find that because of that, again, by clear and convincing evidence, beyond a reasonable doubt, Mr. O'Connor requires a level of supervision provided by a forensic facility. Order him committed to Lakes Crossing, which is a forensic facility. He is entitled to a hearing once a year on whether or not he continues to be incompetent without any ability of attaining competency. Also about his dangers to the community, or whether he should continue to be in a facility. I'm going to set the next hearing for August 30th, 2021 at 1:30 p.m.
Is that 2022, Your Honor?
2022.
It's going by fast, isn't it?
I guess that's why, if I'm still alive or still doing the senior judge thing.
That applies to all of us.
Yeah. Everybody I know is retired. I'm the only one that doesn't seem to have sense enough to do that. Maybe I should get analyzed by the facility. In any event, you want to prepare an order, Mr. Lane?
Of course, Your Honor.
Submit it to the court. Let Mr. Davies look at it ahead of time. Anything more on this matter then?
No, Your Honor.
Okay.
Thank you, Judge. I appreciate
We're in
it.
recess. Everybody can be at ease.